Okay.
All right, this is case study 11 by Group 5 by Alma, Mark, Noah, and Jesus. Next slide.
So the overview, it's basically the introductions, the case overview, based off of management at risk. Then there's the questions answered, and a brief overview of the entire presentation.
My name is Noah Garza. I'm from Austin, Texas, and I'm a senior majoring in architecture. Mark?
My name is Mark Williams, and I'm from Dallas, Texas. And right now I'm in the field with a slight allergy or cold, something. I don't know.
I'm Alma Linares. I'm from Houston. I'm a senior in construction science, and I have some experience in heavy civil as a field engineer.
Jesus isn't here today. He's at work. Next slide. Also, for the case overview, your firm is competitively bidding a hotel project on the waterfront. The market is slow. You have experience in this geographic area as well as the hotel construction area. Your firm has worked with the prime architect on numerous successful projects. The architect is contracted by a national hotel chain that will operate the hotel when complete. Your contract will be with the property owner who is retaining ownership of the dirt, which makes them joint venture, JV partner, and completed facility. In the completed facility, the bid documents include a homegrown contract that appears to have been developed by the hotel's attorney. The contract references an attached AIAA 201 general conditions document, which has been substantially modified. These two contract documents have several conflicts. The bid form requires your officer's signature acknowledging that you do not want to take exceptions to the proposed contract agreement. You know the architect from previous projects and have had an opportunity to review the contract with the hotel operator and discovered that this is also in conflict with the construction contract documents, including AIAA 201. Next slide. This is a quick overview of the 8 questions. Next slide. So for question 1, do you send your contract to your attorney? And I said, yes, it would be a good idea to send your contract to your attorney. Since your attorney specializes in dealing with contracts, they can help break down certain aspects of the contract that may seem confusing and unfair depending on the issues with the current contract. Next question. What is their advice, or what will their advice be? The attorney's advice could be that the contract needs to be revised and edited before any official arrangements are made. It's also important that the attorneys of the firm and the attorney of the owner meet and come to an agreement and go over the revisions with both parties. Next slide.
This is a bonded project. Do you send the contract to your bonding agency? So yes, we know that many construction projects today require that contractors provide bonds, and those construction bonds basically are for protection for the owner against non-payment, lack of performance, company default, and like warranty issues. We also know that if a problem occurs, the owner can file like a claim with the insurer, and the company will pay the owner, with that recouping any additional expenses that occur due to the default. Next question. What will be their advice? So since we know there are 3 types of people involved in this contract, we basically have to say that the bond agency is the surety company that provides like the bond for the project. This is basically the one who's responsible for paying any claims that are filed. So that means depending on who you are, I'm more than sure they're going to say, hey, let's revise the contract given it's necessary. They're going to go in detail about what said person is doing or willing to do, negotiate, and pay. And all this is for legal and money obligations later down the road that they probably want to avoid. All right, next slide.
So do you pull out of the competition? I said no, you don't pull out because um you basically have to keep your good reputation, and if you pull out, I mean, you're basically giving yourself a bad name. And by not pulling out, you're helping not only but your company or the project that you're on um make it like look better and overcome all these challenges. So at the end of the day, you're bringing up success in whichever project you're doing. And so no, just don't pull out. Okay, so for number 6, do you submit a qualification um with your bid stating all of your contract concerns and recommend changes? I also said yes because, I mean, why wouldn't you submit the qualification? I mean, it's going to regard the entire project's process, and so like there should be no problem there. Like, you why wouldn't you submit it, right? And then for your concerns, I mean, what was the second part? And if you're going to recommend changes, you got to also speak up, with the concerns since the very beginning. Um so I said yes to basically all of it.
Question 7. What will your competition do? And I said it's likely that the competition will attempt to convince the owner that they are willing to accept the terms of the contract that the firm deems unsatisfactory, or the competition might attempt to draw up a contract of their own based on the requirements of the current contract. But basically, the competition is just going to try to convince the owner that they're a better fit than the current firm they're using. Next slide.
And then for 8, um do you stay silent to all of this and choose to fight it out after the award, or wait until an issue arises during the course of the project? And we said it's important to not wait for an issue to arise. This could cause other unforeseen problems in the future. If you wait to the end of the project to actually speak up, you're gonna probably end up going over budget trying to go and fix the mistakes that you didn't speak up about, and make it even a longer process. Okay.
And that's the end. Thank you.